his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk
Here,
about
yeah,
off the
because
record,
so
just
we
because
flipped
of
over here.
the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place, and the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides, so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
Okay.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Sainsbury.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but
Okay.
with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe The defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation, a bond hearing or a sentencing hearing. That's is your best forecast, with maybe one exception.
That's correct.
Okay. All right.
Thank you.
Thank you. Ms. Bumpus, want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that, because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not 2 separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not 2 separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff, and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't. And we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or
I will keep everyone in the loop.
Okay, thank you,
Okay.
Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone.
Over to page.
You get it back when you leave.
Where she's still got Mr. Farley up, I believe. Here we go. And I think they just recessed. Of course they did. Or they're going to the next person, maybe. Let me see. Did they just recess? Let me see what happened. Let's back it up. Oh, no, they're going to the next person. Good timing.
And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right, thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right, not December though, not that soon. Okay, so have we covered everybody other than Mr. Mender at this point? Yes. All right, so let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay.
best.
Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's another
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
no, Your Honor.
I didn't think so.
No, it is related
Okay.
to both, but the other witness is not necessarily important for the
Okay.
motion.
All right. So that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay. All right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent and how you're acting in self-defense.
I mean, if he wants, whomever he wants to call, he can call. And I get that. So do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client
Okay.
after discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at
She just rubbed her nose. I just want to point that
sometime
out.
the week of January 13th.
It's fine with the state. And it's just the video, the state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you, I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right, let's do 10 a.m. January 13th.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, I mean, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay, just making sure. All right, and then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want one witness and it would be who we would need in production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Evans.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of
Okay, I guess it's over. They are wild. She was in the middle of a sentence. Let me see if anybody. What in the world? What was that? Oh, it's over. Okay, well, they could have said, okay, we're wrapping it up now or something. Went to the seal. They just went, okay. Okay, well, shots fired across the bow from the prosecution on the side of Yak Gotti. He said, "You want to know why this jail is so bad? Well, there's your reason right there." And points at Yak. What was that? That was awful. I couldn't believe he did that. That was so horrible to do. Let's see if I can find that real quick where he did that. I mean, that was unnecessary. I mean, I know you got to make, your defense or whatever, make your reasoning for why he shouldn't be out on bail, but that was too much. Way too much. Let's see if I can find it. What did y'all think about that? Wow, that was crazy. I can't find it right now, but I'll make a clip of it and make sure it gets up on the channel. Thank you guys for coming in and joining me. It's good to, it's actually good to see the seal again. Good old seal, good old Georgia State seal. Thank you guys. I hope y'all have a fantastic day. It was an odd ending. Yeah, it kind of just closed out. Usually they go back to the seal. But if y'all have any questions, please put them down in the comment section. I'll make sure they get addressed and make a video about it. Y'all have a fantastic day, and we will see you guys later. Grace and peace, everybody.
Hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it.